Vergils. I will sign the petition for a court-appointed lawyer.
Thank you, and good afternoon, Your Honor. Assistant Public Defender Chelsea Vergils, with and on behalf of Lita Johnson, we would waive a formal reading of the charges, stand mute, and ask to address bond.
Okay, go ahead, Ms. Robbins.
Your Honor, I just want to make sure that we are on Ms. Lita
Johnson, 24F10175. Yes.
Thank you, Your Honor. We're not asking for a monetary component in this case, but we would ask for drug and alcohol testing. Also an alcohol tether, giving the allegations that the police believe she appeared to be intoxicated during the event. No go to the 5900 North Linville and Westland address, and no contact with, and again, I know we're on YouTube, so I think I'm going to leave that name off.
So that the alleged victim in this case, my understanding is she's now living in Westland. And do we know if there are any Child Protective Services orders?
Not that I'm aware of, Your Honor.
Ms. Johnson, did you have contact with Child Protective Services by any chance? Okay.
Yes, I did. She came out to my home last week.
Okay. And are there, again, we're on YouTube, so you don't need to go into all the details about it, but are there, was there a plan made for you to see your child?
No, she just told me that she was coming out to check on everything because
so the way that I usually order contact in a case like yours is that whatever Child Protective Services allows is okay with your bond. All right. So if that means that if the recommendation is that you not have contact, then you can't have contact. If the recommendation is you have contact, if that's what your child wants, then that's okay. If it's supervised contact, then that's what you need to do. So the reason that I do it that way is that while you're working with Protective Services to get a safety plan and get your family back together, I don't want you to have to keep running back to court to get your court order changed. Okay. So that way the court order is you may see your child as permitted by Child Protective Services, and you are to follow all court orders issued by Child Protective Services. Okay. We're going to talk about some other stuff too, but that's what I want to tell you about how I'm going to order that for your child. Go ahead, Ms. Vergils.
Thank you, Your Honor. I spoke with my client this morning, and she informed me that she has been living with her aunt in Detroit. Her aunt has lived there since 2009, and she has two kids. Her other child is a son who is disabled, so she has full custody of her son. And when she is not taking care of him, she participates in a Learn to Earn program to work on getting her CNA. So she's eager to get back to her studies. I would ask for a personal bond in this case. And my client has no problem with drug and alcohol testing. I would ask for you to consider no tether, as she reports to me she does not have a long-term substance abuse problem or anything like that. So I'd ask you to consider no tether with the PR bond in this case.
Okay, thank you. So I'm giving you a personal bond, Ms. Johnson. You don't have to pay any money to leave the jail. I'm ordering that you have contact with your daughter as permitted by Child Protective Services. I am going to order random drug and alcohol testing. You'll need to start that here in Washtenaw County tomorrow. And then if you want to transfer that to someplace closer to your home in Detroit, you can help. They could, Community Corrections can help you get that set up closer to home.
Yes, can I please transfer it?
Yep, I'll put in the order that you can test in Wayne County.
Okay.
Okay, I'm ordering you to comply with all obligations and recommendations from CPS as part of your bond. Do not use alcohol, marijuana, or illegal drugs. No purchase or possession of firearms, weapons, or ammunition. Do not leave the state of Michigan without permission of the court, and no criminal or assaultive behavior of any kind. Okay, I'm not ordering a GPS tether. I don't think that's necessary, since I'm permitting you to have contact with your child as appropriate. I will order you, okay, so regarding that address in Westland, I'm not going to order you not to be there specifically, but again, that's part of this following CPS orders, okay?
Okay, we have two felony files here today. State of Michigan versus Tariq Lee, 24F10260 and 24FB1035. I will appoint the public defender's office. We will handle I'm not going to go over your contact information because we are on YouTube, but is the information that you provided to the public defender's office the best way for the court to contact you?
Yes.
Okay, thank you. I will make sure that that information is in both of your files. Go ahead when you're ready, Ms. Pate.
Thank you, Your Honor. Assistant Public Defender Natalie Pate for Mr. Lee. At this time, we do stand mute. We waive formal reading of the complaint, stand mute, and ask to address bond when appropriate.
Go ahead, Ms. Robbins.
Your Honor, so I believe we're here on two incidents. The first one from February 5th, when officers attempted a traffic stop on Mr. Lee, whose registration came back suspended. When they approached the vehicle, Mr. Lee drove off and extinguished his lights at nighttime. And then less than a month after this incident, on February 22nd, is when the highway situation occurred. There were two vehicles, both driving erratically, and Mr. Lee pulled a gun, fired at least 2 shots at the victim vehicle, ultimately crashed into a third vehicle. All this occurring on the highway is obviously concerning and from a public safety perspective, and could have gone much, much worse. Mr. Lee then ran from the crash scene. He told the police it was because he had warrants at the time. This could have resulted pretty easily in multiple fatalities, with gunshots, erratic driving, crashing. So in the freeway shooting case, we are asking for a $50,000 surety bond. In the other case, we're asking for a $25,000 surety bond, as well as, if he is released, home confinement with a tether, other standard conditions, and no contact with the victim or witnesses. The ones I'm primarily concerned with are Nolan Ahrens and Tyron Steels.
Okay, thank you. Go ahead, Ms. Pate.
Thank you, Your Honor. At this time, we respectfully request this court to set a cash surety bond in both matters as low as the court would deem appropriate. I did go over potential bond conditions with my client, and he states he has no problem complying with any. However, a home confinement tether would largely curtail his life, as he does work more than full time at a electronics company. He works 10-hour shifts. He's been there for a year. We do respectfully request the court to set a very low cash surety bond on both matters. My client informs me that even a 10% privilege on either file that for what the people are requesting would essentially keep him in custody. He would not be able to post even 10% of what the people are requesting. To my understanding, my client only has one prior conviction. He does reside with his grandma at the address provided to the court. He is not a flight risk, and notwithstanding these allegations, my client does maintain he's not at all a danger, and he will be returning to court and complying with any bond conditions as set by this court. We do respectfully request a low cash surety bond. Thank you.
Okay, Mr. Lee, bond has essentially two components. One is whether the defendant is a flight risk. The other is whether or not the defendant presents a danger to the community. The facts as they've been presented to me today, both in this hearing, but also in the complaints themselves and from the Washtenaw County Sheriff's Department and the Michigan State Police, are that you are both a danger and a flight risk. You're accused in both files of fleeing from the police officers acting in their lawful duty. And in the file from yesterday, you're accused of firing a gun at another vehicle on the freeway, which you must have had some reason that you thought that made sense. But of course, it's an extremely dangerous situation. If you had damaged that other vehicle in a way that caused it to go off the road, if it had shot the other driver, another person not involved in the road rage, all kinds of things that I'm sure, like me, you can imagine might have happened had that gone just a little bit worse than it did. So I do not think that a personal bond is appropriate in either file. The next part of the question then is whether the bond should be in an amount that might keep you in custody or not. I don't really think that you should need to be out of jail right now. So I'm not going to set a bond that necessarily would keep you in jail. That's not what I think is appropriate either, but it doesn't really matter right now whether you can post it given these allegations is where I am right now on this. So I'm adopting the prosecutor's bond recommendation on each file, $50,000 on the shooting case 24F10260 and $25,000 on the fleeing and eluding. For both files, you're not to use illegal drugs while you're on bond, no purchase or possession of firearms, weapons, or ammunition. Do not leave the state of Michigan without permission of the court. No criminal behavior and no assaultive behavior while you are on bond. Your court date for both cases will be on March 7th at 9 a.m. If you post your bond, you'll need to come back and appear in person. If you have not posted the bond and you're still in custody, the corrections officers will make sure that you are presented at court at the right time.
I have a question.
Okay, remember, I'm reminding you we're on YouTube. Okay, so go ahead.
So you saying that it's $75,000 for my bond total?
Yes, yes.
So I won't be getting out.
Well, that's not, I suppose that might be true. Like I said, that's not really my primary concern right now.
Yes, ma'am. I want you to know that
Anything
I'm
else?
deeply sorry.
You don't need to say anything. I'm going to suggest that you not, because again, this is being broadcast onto YouTube and whatever you say is likely to end up in the newspaper. And maybe you don't even need that. All right. It's not necessary for you to say anything today. Okay, you are all set. When you're ready, you can stand up and walk back to the door. Thank you.
Thank you, Your Honor. Thank you, Mr. Lee.
This is State of Michigan versus Ryan Johnson, 24FB 1026. I will appoint the public defender's office. Go ahead when you're ready, Ms. Vergils.
Assistant Public Defender Chelsea Vergil with and on behalf of Ryan Johnson, we would waive a formal reading of the complaint, stand mute as to the charges, and ask to address bond.
All right, whoever's speaking from the prosecutor, is that you, Ms. Barroso? Go ahead when you're ready.
Good afternoon, Your Honor. This is Assistant Prosecuting Attorney Morgan Barroso on behalf of the people. I am aware that you did the swear to, so I would like to place some of the facts regarding this case on the record, just so that the record is clear as to why we're making the requests we are making.
Okay, and reminding you that we are on YouTube, so careful about the things we don't necessarily want broadcast.
Absolutely, Your Honor. First, I would like to make the request that we are asking for $500,000 cash or surety as far as the monetary amount on this bond, as well as a do not go to for the Julie Street address, home confinement with a tether upon release, as well as no contact for the co-defendant in this case, which is one Julius Clay, Kimberly Bullocks, Alan.
I don't know anything, excuse me, wait, I don't know anything about a co-defendant.
There
wasn't one on the complaint. And I didn't hear anything in the testimony, so.
I apologize if there was not one listed on the complaint. However, a warrant was written for that this morning. I do not believe that that was part of the swear to. However, it was written. I don't believe that it was that came before you. If Mr. Clay was left off of the complaint, that was an error. There is a co-defendant in this matter.
All right, is his information in the bond form for me to add to lien?
It should be, Your Honor. His name is included in the request for the no contact order as one of the individuals for the no contact order.
Okay, I do see that on here, yes.
Okay.
His name is not on the complaint. Do you want that added?
Yes, please.
Okay, I will make that amendment at your request. Go ahead.
So Julius, no contact with Julius Clay, Kimberly Bullocks, Alan Duva, and Javier Bullocks. Like I said, in addition, or the reason for those requests is because of the nature of this case, as well as the defendant's lengthy criminal history. I do want to emphasize a few of the facts underlying this case in support of our requests. 3 days prior to this incident, the defendant and the victim, Miss Kimberly Bullocks, had an exchange where the defendant conveyed to her that he wanted the minor child in question. When she said no, he said, "I'll be back for him." Fast forward to February 7th, between 3 and 4 a.m., Kimberly Bullock was up feeding the baby when she heard banging on the door. She did not expect anyone there, neither did Alan Duva, who also resides at the residence. So Alan, who is an elderly individual, went and opened the front door. When the front door was opened, Mr. Johnson and Mr. Clay barged their way into the residence with guns, knocking Alan over. It's unclear if he hit his head or if he was hit with one of the guns, but he had a large knot on his head. Julius then proceeded to hold Kimberly and Alan at gunpoint, and while Ryan Johnson took the minor child from the residence, placed him in a vehicle, and came back in the residence to gather some of the minor child's belongings. Ryan then proceeded to take the minor child to the Victory Inn. At that point, Ryan Johnson and co-defendant Julius Clay parted ways. We still are unsure of Mr. Clay's whereabouts. However, Mr. Johnson was at the Victory Inn in possession of the minor child. SWAT was dispatched there. They were able to safely get the baby out of the hotel, and he was arrested. I do want to emphasize that the defendant has a 2003 conviction for armed robbery, as well as aggravated vehicle hijacking with a firearm out of Illinois. He has an extensive number of B&Es with intent from the 3rd and 22nd Circuit between 2001 and 2002, as well as an R&O and a fleeing 4th from 2002, and 2 counts of home invasion 2nd from 2009 out of the 22nd Circuit Court.
Okay, so
Lion bitch.
Mr. Johnson, I would advise
Okay.
you not to speak at
Mr.
this time.
Johnson, Mr. Johnson, I don't have to arraign you if you're uncooperative. It's in your best interest to cooperate with the arraignment so your case can proceed. Uncooperative in my courtroom means that you are using profanity towards any person on this call, or that you are interrupting, or in any other way are belligerent and inappropriate in your behavior. You understand?
Yeah, it is. So it is.
Okay. We'll see you tomorrow. Goodbye. Step out. Defendant has refused to be arraigned by using inappropriate language during the arraignment proceedings. We'll try on, we can try tomorrow. It's a Saturday, I'm working. So if that's something that we decide to do, or we'll do it on Monday.
What's your name, sir?
Ryan Johnson.
Okay, Mr. Johnson, we're gonna handle your arraignment today. Ms. Barroso, I don't think we need to go through everything again. As you know, we put that stuff on the record on Friday. I took the testimony on the complaint. I think part of what was bothering Mr. Johnson on Friday is having all of that stuff read out loud, and I can't blame him. It's hard to listen to what other people are saying about you. State of Michigan versus Johnson 24FB 1026. I've already appointed the public defender's office. I've already updated Mr. Johnson's contact information. So if there's anything you want to put on the record regarding bond right now, Ms. Barroso, and I'm reminding everyone we are on YouTube today. Go ahead when you're ready.
Assistant Prosecuting Attorney Morgan Barroso on behalf of the people. Thank you, Your Honor. I was not sure if you were doing the arraignment today, if you personally were handling it, so I wanted to appear just in case I needed to repeat that for the record. At this time, I would rest on what was previously stated on Friday.
Okay, thank you. Go ahead, Ms. Vergils.
Thank you, Your Honor. I've gotten a chance to speak with my client a couple times now, and he informed me that he has been working full-time at Applebee's for the past 2 years and has family in the area. However, he is homeless, so any cash bond really would be a hardship for him. From what I understand, he does not live near the complaining witnesses in this case and is committed to staying away from them and following his bond conditions. I would argue I believe it was an isolated incident. My client, from what I can tell, has not had a felony conviction in the past 15 years. So I would ask you to consider allowing him to post 10% of whatever cash bond. And he is also open to home confinement tether upon release, if released. Thank you.
Okay. Detective Morrison, did you want to say anything on this case?
Your Honor, so the only thing that I would request is that you have Mr. Johnson comply with his mental health plan that's currently in place. He hasn't been compliant since October of 2023.
Okay, thank you. Okay, Mr. Johnson, so this is the continuation of your arraignment from the other day. We'll go through the easy parts first. No contact with the alleged victim, Kimberly Bullock, Javier Bullock, Alan Duva. No contact with the co-defendant, Mr. Clay. I think it's Julius Clay. Do not go to the address on Julie Drive in Ypsilanti. I am ordering a GPS tether with that location as the hotspot. So before you can leave the jail, whenever that may be, you'll need to have a tether set up with the hotspot of that address on Julie Drive in Ypsilanti Township. While you're on bond, you're not to use alcohol, marijuana, or illegal drugs. No purchase or possession of firearms, weapons, or ammunition. Do not leave the state of Michigan without permission of the court. No criminal behavior and no assaultive behavior. The financial component of the bond has two parts to it. One is whether the defendant is a flight risk. I think what speaks to flight risk specifically in your situation, two things. One, a history of failing to appear in court, and two, the instability of your current housing situation. More importantly, though, I think we're concerned with danger to the community. So there's a fairly violent criminal history, including charges of resisting and obstructing. There's a carjacking conviction, lots of breaking and entering with intent. Those aren't necessarily violent. Home invasion, again, not necessarily violent. And in this particular case, the allegations are with another person holding some people at gunpoint in order to essentially kidnap an infant. You're not charged with that, but that's essentially what was occurring. So that presents a very dangerous situation. Anytime firearms are involved in a crime, the risk of harm to people is high. Your lawyer's points notwithstanding, this does appear to be an isolated incident in the sense that this is not the kind of crime you're usually charged with. However, given your history of mental health concerns and the fact that this occurred, that says to me that there's something going on right now that is creating this dangerous situation. So I'm setting the bond at 500 million, nope, 5 million, sorry, too many, nope, 5 million, sorry, too many zeros. $5 million, no 10%. That's the bond for now. That can always be looked at again in the future if it's appropriate to change that. The GPS tether, all of those other conditions that I listed, and I am also ordering you, if and when you are released from custody, to comply with any existing mental health treatment plan. The court date for this case will be on Thursday, February 22nd. That will be at 9 a.m. in person with Judge Simpson. Anybody have anything else on this matter?
No, Your Honor, thank you.
No, Your Honor, thank you.
Mr. Johnson, you are all set. When you're ready, you can stand up and walk to the door.